Hello, my name is Ian Larkins of Radius Law and welcome to our commercial bulletin in association with LexisNexis. The government has confirmed that, subject to parliamentary approval, new regulations will come into force on the 6th of April, obliging large private and publicly quoted companies to make annual climate-related disclosures. Detailed information is included in the consultation response, which is available on the government website. It's a common misconception that non-executive directors do not bear the same liability as executive directors, but actually the liability is the same. In a recent case, a non-executive director of a company that was being investigated for VAT fraud was disqualified as a director for 4 years. Now, it was acknowledged that he had no day-to-day involvement in the company, but he had signed off the company's financial statements without investigating the auditor's concerns about the fast growth of the business. The Law Commission has confirmed that the current legal framework is clearly able to facilitate and support the use of smart legal contracts. A smart legal contract is a legally binding contract which some or all of the obligations are recorded in and/or performed automatically by a computer program. The Law Commission has acknowledged that there will be some obstacles to navigate, with deeds which must be witnessed and attested, and determining jurisdiction and applicable law, so recommends that the express choice of law and jurisdiction clauses are included. In responding to concerns about interpreting coded terms, the Law Commission has stated that the appropriate legal test is what a person with knowledge and understanding of code would understand the coded term to mean. Appendix 3 of the Law Commission paper helpfully includes a non-exhaustive list of issues that the parties may wish to address in their smart legal contracts. Contracts will often state whether a party is to use reasonable or best endeavours to do something. It is commonly understood that a reasonable endeavours obligation will be discharged if one reasonable path is taken, whereas best endeavours requires all reasonable actions to be exhausted, even if that means sacrificing a party's own commercial interests. Now, sometimes there are twists on these well understood terms, including obliging a party to use all reasonable endeavours. A judge in a recent case that concerned a contractual obligation to use all reasonable endeavours explained that it is a high standard and any passivity or inactivity is likely to be construed as a breach. The judge found that the defendant had not met this obligation even when conceptually this may have involved a commercial sacrifice on its part. There has been a recent flurry of data protection fines or notices of fines. Amazon has been fined €746 million by Luxembourg's Data Protection Authority. The specifics are not publicly available, but it is understood to relate to Amazon's advertising targeting system being carried out without free consent. Amazon has filed an appeal. The UK Information Commissioner, the ICO, has issued a notice of intent to impose a £70 million fine on Clearview AI Inc. It is alleged that Clearview holds a 10 billion image database that is scraped from the internet and that enables subscribers to face search using biometric and facial recognition searches. A final decision from the ICO is not anticipated until mid-2022. The Irish Data Protection Authority, the DPC, has fined Twitter €450,000 for failure to give a proper notice of a data protection breach to the regulator within the 72-hour required timeframe. In addition, the notice failed to explain the reasons for the delayed reporting. The ICO has fined the Cabinet Office £500,000 for uploading the 2020 New Year's Honours recipient list, which accidentally included a supposedly deleted file that contained the addresses of more than 1,000 people, including those with a high public profile. The case of Lloyd v Google concerned an opt-out class action for Google's alleged tracking of users' internet activity without their consent. The claim sought a uniform sum on behalf of 4 million Apple iPhone users. The claim was brought under the old Data Protection Act 1998, and the court determined that this law does not provide a right to compensation without evidence of material damage. Also, as the individual effect of the breach would differ from person to person, with each individual experiencing different levels of financial loss or mental distress, the claim would not meet the same interest requirement for class actions. Now, future similar claims are likely to be more successful, as the revised law states that a mere loss of control of personal data may amount to the right to compensation. At the end of November, the ICO published its opinion on data protection and privacy expectations for online advertising proposals. This is a continuation of the ICO's broader AdTech and real-time bidding (RTB) report. Now, RTB is a process whereby web adverts are sold at the blink of an eye based on the user profile. The opinion has a tone of frustration of the lack of progress since the ICO first expressed privacy concerns about the AdTech sector in mid-2019, when it stated that it considered all current real-time bidding practices to be non-compliant with the GDPR. The ICO notes some of the industry's proposals aimed at improving user choice and users' ability to express preferences with online tracking, but does not seem satisfied that any of them have been successful. It also mentions Google's Privacy Sandbox, a proposal to move away from tracking cookies, but notes that none of these proposals are fully developed yet. The opinion states the principles which the Commissioner expects any AdTech solution to meet to comply with data protection. Data protection by design should be incorporated during the design phase of the initiative. User choice must allow meaningful control and the ability to exercise data subject rights. Accountability must exist across the processing supply chain and include transparent responsibilities for market participants. Purposes of data processing must be clearly explained, necessary and proportionate. And there must be reducing harm by ensuring that privacy risks are addressed, such as through DPIAs. New guidance on misleading environmental claims and social responsibility in advertising has been published by the Committee of Advertising Practice, CAP, and the Broadcast Committee of Advertising Practice, BCAP. The new guidance aims to assist marketers and agencies with interpreting the rules concerning environment-related advertising issues and provides a general overview of the principles underpinning the ASA's rules more generally. To change contracts of employment, some employers have resorted to fire and rehire tactics, which involves terminating an employee's contract of employment and subsequently offering alternative terms of employment, often less favourable. ACAS has now published advice to employers which warns against the practice of fire and rehire and encourages them to consider the following to make changes to contracts of employment: the necessity of amending contracts of employment in the given circumstances, consultation requirements, how to deal with changes to employment contracts where variations are agreed, and how to deal with changes to employment contracts where the variations are not agreed. To support businesses during the recent surge in the coronavirus cases, the government is reintroducing the statutory sick pay rebate scheme. The previous scheme ended on the 30th of September of 2021. Now, this means that small and medium-sized businesses with fewer than 250 employees can seek reimbursement for statutory sick pay for up to 2 weeks where staff have been off sick due to coronavirus-related absence. The Chartered Institute of Personnel and Development, CIPD, has, on behalf of the government's Flexible Working Task Force, published new practical guidance on hybrid working. The guidance covers areas as varied as recruitment, health and safety, and ensuring policies and practices are inclusive and fair. A recent Court of Appeal decision has highlighted some key issues for any business which uses software developed by employees. The employer claimed that it was the owner of software that had been developed by the employee because it was mostly created in the course of his employment, and any earlier software was assigned to it by an agreement between the parties in 2008. Now, whilst the employer was ultimately successful, the court case caused it much disruption and unrecoverable costs, spanning over 3 years. The employee's key argument was that if the intention of the contract had been to capture software that was partly developed before his employment and outside normal working hours, it would have been much clearer on this point. A recent Employment Appeal Tribunal (EAT) ruling concerned a disabled employee who, following a 2-year-long period of sickness absence, was dismissed on the grounds of ill health capability. The employer considered that a dismissal was a proportionate means of achieving the legitimate aim of the efficient running of a department, but the EAT ruled that before resorting to a dismissal, employers must consider other less discriminatory measures. In this case, for example, it was not clear why the employer was unable to appoint a temporary replacement for the claimant. It has generally been understood that for the purposes of calculating whether an employer has complied with the National Minimum Wage, the NMW, that it is the net pay after the employee has paid for items required for the work, such as compulsory staff uniform. But the EAT has ruled in a recent case that it is the net pay after any expenditure in connection with the employment. In this case, the employee, a minicab driver, purchased an optional uniform and at his choice hired a car from a company connected with the employer rather than using his own car. The EAT ruled that his wage after these optional costs must meet or exceed the NMW. That's it for this month. Thank you for tuning in. We've included the links to all of the documents we referred to today in the written version of this bulletin, but please don't hesitate to reach out to me or any of my colleagues here at Radius Law for more information.